Right, welcome everybody. Let's see. There we go. All right, welcome everybody. I'm Rich Frawley. I am the Director of Training here at ADF Solutions. I've been with ADF Solutions over 7 years now after retiring from law enforcement. 22 years in law enforcement, 17 of those as a forensic examiner and investigator with the Milford Police Department up in Connecticut. So in this month's webinar, we are going to do it a little bit different. We're going to have a little conversation here with Rich Colangelo. We're going to be getting into victim witness and consent cases. So, you have a victim or witness in something, or you have a cooperating suspect that's given you consent on mobile devices. We're going to kind of go over how that works, how it should work, how it can work, and everything in between. So we have our question panel open. If you have any questions, please send those through to us and we'll take a look at them and either save them for the end or get to them as we're going through. Any issues, please send them through so I can take a look at them as well. Seems like I've been talking a little bit and everybody's paying attention and can understand and see us, I'm hoping. With that, let me introduce Rich Colangelo, and I told him I was going to let him introduce and give you all his credentials so I don't step on anything. Rich, nice to have you with us, and thanks for being here.
Thank you, Rich. Thanks for having me. Everyone, my name is Rich Colangelo. I retired as the Chief State's Attorney in Connecticut. I was prosecutor for 29 years in Connecticut. Line prosecutor for 20 of them. Then I was appointed State's Attorney for the Judicial District of Stamford and Norwalk. Before I became State's Attorney, I was able to get a grant, a federal grant in my jurisdiction to train law enforcement to do digital forensics, computers and then cell phones, because we weren't doing many cell phones back then. We were spending a lot of time with computers. At the time, I had all of the member departments sign MOUs. I had them all become ICAC affiliates. Once the grant ran out, I convinced each chief of now it's actually 12 departments, to pay a participation fee. Found an offsite office in Weston, Connecticut, and now the chiefs are actually staffing the lab. So any day from Monday through Friday, probably 8 to 4, you'll go in and see one of the officers from one of the departments working on their cases or cases for another department. We were able to incorporate and become a 501c3 corporation. So it allows us to share the equipment, resources, and since every case we have now has digital evidence in it, it allows us to work through those cases a lot more efficiently.
Right. Yeah. So we go back quite a ways working together here in Connecticut.
They were thinking it was about 25 years now, Rich? Something like that?
I'm thinking we were talking about it earlier. One of the first times we met was for a case that was happening in my town, and I had already been established as a unit. So we worked together on that, and it was awesome. So I know you talked about that digital evidence or the task force that you're in, and but can you tell me a little bit more of your involvement specifically with the digital evidence and the task force you were in charge of?
One of the things I realized as a prosecutor, right, is as a prosecutor, you can't do your job unless law enforcement is doing their job really well. And in seeing that, the way that the cases were progressing, I started handling the sex assault cases. Then I started handling the cases with minors, and then minors are getting involved on the internet. And we had, undercover operations. Who's trying to lure a minor? So we were looking at that digital evidence. So I found it really important to, have not only a dialogue, but an understanding of what my examiners and officers were doing so that I could explain it in court. And that's kind of the way that I started getting involved in these cases. And then it just snowballed from there. I mean, I bring my officers in, when a case comes up, they're doing their investigation. I'm working with a detective. Okay, what forensically can we look at? So then it goes to we get the forensic examiners. And it's a constant back and forth between, me when I was a prosecutor with the detective and then the forensic examiner on, what could we look at? What should we look at? And that kind of exploded in actually the last case that I ended up prosecuting before I became chief state's attorney. I was involved in a missing mom case, Jennifer Doulos at a New Canaan. And, not only is there a lot of digital evidence in that case, but there was a lot of video evidence. So, things just snowballed and it was all hands on deck.
Yeah. Yeah. Well, video evidence as well. Yeah, that was a big lot of stuff came across in that case. Yeah, having that direct relationship with your examiners providing you the evidence it's got to be,
Well, it's
I
so
would say,
important, Rich, because
advantageous in a way, because I know when we were doing it, I had a great relationship with our prosecutors, but it wasn't direct. It was, I would have different prosecutors at different times. Sometimes I would be the teacher, or trying to figure out what can or what can't I do. So it must have been, I mean, that relationship directly with the task force and having this stuff. Did that help cut down on the calls and when it comes to court? Hey, I'm missing something.
absolutely it does. I mean, if you think about it, when law enforcement goes and gets a search warrant for digital evidence on a evidence that could be stored digitally on any device that's going to store it, whether it be a digital depiction of something or a communication about a particular crime, right? That search warrant is going to go out. The officers are going to search, seize that device, now look for that information. And one of the things that courts are doing now, with law enforcement, particularly with those search warrants, is making sure that our scope is very narrow, making sure that we have probable cause for each specific item that we're looking for in every place that we're looking for it. So having that relationship and the direct line of communication with the examiners, allows for a lot of the cutting through the extra material for the case. Okay, what do you have? And I'll sit down with them when they're initially doing their examination, after they extracted and loaded everything into whatever tool they're going to use. All right, let's go through it. Give me, here's what's the date range? What are we looking at? This is what I really need. I need a location about this. We have the search warrant for it. And it's easy for an examiner to get the low-hanging fruit. It is. I mean, and you guys love that when somebody says, hey, give me all the text messages between this date and this date. Boom, press the button. Here you go. I'm on to my next case. But when you have to actually, connect the defendant to a particular place or a particular event or a particular photograph, that's when at least I find when examiners, really get involved and enjoy the job, if that makes sense.
Oh yeah, yeah. One of the things that attracted me to this was the puzzle, was the, I need A, B, and C. Where is it, and how can I best get and present that to you?
And
And
as you know, I
search
mean,
warrants were always the thing. It's like, yeah, you have to spell out what you're looking for and where it's going to be. So that's going to lead us down the road here into some of the other questions we have as well.
right. And then that search warrant is what we're utilizing to get information, usually from a defendant or an involved individual in a particular case.
Yeah.
More than likely, if you have a victim or a cooperating witness, they're going to give you consent. And while we spend a lot of time worrying about the constitutional rights of defendants or accused, which we should, we kind of forget about those same rights for witnesses or victims or people that are, providing us with consent to give us a particular piece of evidence for our case. We've had situations where, crimes were committed in front of groups of individuals, right? We had a shooting in Stanford, downtown Stanford, when the bars were letting out and people were videotaping it. So, we get consent to search somebody's phone to extract that video, and the officers weren't very targeted in their consent. We said, we want to get the information from your phone about the event. So we get a whole extraction from the cooperating witness's phone, and they have the video of the guy running out with the gun. And they also have all of the personal pictures, all of the personal text messages that they have as part of that extraction. Now they have it, they turn it over to the prosecutor, so it becomes part of my file, which becomes part of discovery. So now that one video is really what we should have gotten, because that's really what they wanted. That's what the person was providing, or said, hey, I have. Showed it to the officer, the patrol officer, and then hey, detective, we need to get this person's phone. And then it kind of went sideways from there for that witness, because they spent more time on the stand testifying about things that were in their phone that weren't relevant. But, the judge allowed it because it was cross-examination. And as a
Right.
prosecutor, I couldn't do anything to stop that cross-examination. I objected, often, but the judge was of the mind that, we're going to let them cross-examine this individual about everything else.
Yeah, it's almost like, hey, you brought it here, so you know.
Right, right, and that's the issue that we have, and it becomes more magnified when you're dealing with a victim in a case who was
Right.
threatened or assaulted or abused, and they have evidence on their device that they want to provide us, and so we do a whole extraction on their device, and now
Right.
what do we do? So that targeted consent is going to be almost as important for law enforcement as is scope of the search warrants we're going to be dealing with.
Yeah, and this is awesome. We're leading down here because my next question for you leads into that. But um, you know, ADF has a tool, targeted consent, screenshot, screen recordings. I've been banging the drum on that, for a year. And one of the things I haven't done is actually talk to a prosecutor and an expert on that side of the fence, and had this come out. So it's awesome that we're able to talk about this. And you're saying, you've got a witness who videoed something and they're 100% willing to give you that. You could have this recording, you could have these screenshots. Um, for a witness at something like that, that's great. When we're talking victims, it gets a little bit more sensitive, if more is going to be done. So a little more needed, maybe, like you said, in the sexual assault realm there. But how many times have you seen or heard from your investigators that digital evidence walked away because of that reluctant victim or witness? You're sitting there talking to somebody, you don't have enough to do that search warrant. You're looking for just a couple of items. You don't want to scare them away. And they're like, hey, I'll give you A, B, and C, but you're not walking in the other room with my phone, or you're not taking it for 5 hours. That's my lifeline.
Right. I mean, it happens more times than you can count, honestly, Rich. And it's that situation exactly where you get an individual and we know that a lot of these crimes, when a crime occurs, in certain areas of the country or parts of the state or city, wherever you are, that individuals are reluctant to talk to the police. And they can be reluctant for a lot of different reasons. One, if they don't trust the police, or it's the kind of the code of their neighborhood. They don't want people to know that they're talking to the police. So just in that instance, gaining someone's trust or giving them the ability to help. And if you think about it logically, they want to help because these crimes are happening in their neighborhood. They're just scared to do anything about it because of the people that are controlling the area, people that might, their fear of that retaliation. So being able to do that screen capture of a picture that they took, or the screen recording of a video, doing it forensically, so that we have the ability to hash it. So I know that what I'm getting is what it is, and if I provide that to someone else, or that video comes in from another source, I can compare it to see if they're the same or not. And that's another issue that we have in these cases. Uh, we run in the, a victim one day could be a witness another, could be a defendant the third. And those witnesses to an offense, are they on the victim side? Are they on the defendant side? Where are they coming from? So it's that relationship that we have to worry about in law enforcement and try to figure it out. So, getting the information will allow us to do that old-fashioned police work, right? Do the investigating. But, capturing the data is the important thing as quickly as we can have it. Because when you have it early, instead of waiting the 5 hours to do the phone extraction, and you have a person of interest, somebody you want to talk to, you're going to be able to have a lot more intelligent, in-depth conversation with them by having that video right away instead of waiting for the extraction.
Right. Yeah. Yeah, and you hit on that. I always say digital evidence is awesome. It's pretty much involved in every case there is now, and kind of a scary prospect for some people doing investigations. Like, oh, it's digital, it's mobile, it's but not to slight anybody doing this work. Examiners are awesome, they have their place, but a lot of times it comes down to that investigator, to that good old-fashioned police work, right? It's what gets you there. As investigators, we have tactics that we can deploy, in order to attain what's necessary. And that, along with compassionate policing, if I can use a buzzword, not one I necessarily like, because I think police have always been compassionate, but employing that along, usually that's what gets us to the goal line and getting us that information, letting us say, okay, here, sit next to me. Here's the phone. Show me where this is. I'll have this tool right in front of me, and this is what we're going to take, and you'll see what I'm taking. So
it's huge, right?
Yep.
I mean, that's so huge. And I don't mean to jump in, Rich, but that's that part of the process, right? Involving the victim or the witness in the process, explaining to them what you're doing, having them show you where it is, and showing them what you took, right? It just builds that trust. It builds that relationship that we're going to need to keep them as a witness in the case going forward. I mean, as a prosecutor, I can't tell you how many times I had to reestablish a relationship with a victim or a witness because a police officer either oversold something, undersold it, or didn't want to give them the time of day.
Right.
Right. And everything you're talking about just goes to that relationship.
Yeah. So what do you like to see out of that? So if I have a cooperating witness and I'm working them, is there any, what's that?
There's a pop-up on your machine.
Oh, yeah, thank you.
Sorry.
My USB device is reconnected there. So that's what's in my folder. No secrets, transparent here. Live TV, folks. Yeah, so like you were saying, and I guess you kind of answered this question for me already. It's the over or underselling of something, or using a wrong tactic instead of getting right in there and working with either. I mean, victim and witness is kind of probably a little easier on that compassion side. I think cooperating suspect is difficult for some people. Uh, I mean, when we did the child exploitation cases and CSAM cases, it's tough to interview those people because you have to interview them as them, compassionate, empathy, right? You have to see it from their side.
Well, that's going to get them speaking. I mean, that's really what you want to do. And you want to get them locked into a story so that we could either prove or disprove what they're saying or working, for the case, right? That's the number one issue. in that type of situation. But one of the greatest issues we have now with consent in law enforcement's world, right? The case law used to be that if you get consent from someone and you start your extraction and you do your extraction and they withdraw consent, whatever you got, you can continue to use. Right? The case came down, and I'm not going to remember where it came from, but recently, it's within the last 2 weeks. I remember reading it. I'm sorry, I should have wrote it down. But the court held in that case that the consent ran to the process, and once it ran to the evidence. Right? I consent you to get this evidence. And whether once the consent was withdrawn, you don't have the ability to interact with that evidence anymore. So that's why being able to go in and be strategic with even cooperating defendants is going to be, huge now, right? We need to have the ability to, hey, yeah, you could look at, my text messages. All right, so we're going to get the text messages between the defendant and the victim on consent. So we have the ability to do those screen captures. If we're doing a whole extraction, well, that evidence is gone if they withdraw their consent. If we're capturing it right away and running with it in the investigation, I think we have a lot better argument to make that, we showed them what we were taking. We took it while they were sitting there. They didn't withdraw consent, and we move forward. Maybe it should be, to cover ourselves with that new case law, maybe it's potentially we do kind of a two-step process with the consent. Right? It's consent to get this information, and then almost like a return on a search warrant. We took this, and I'd like you to sign off on it. When you have that competent individual.
It's funny you mentioned that, and I don't know if we have anybody here, but we have a lot of customers over in the UK, and that is what was recently implemented over there. Consent laws over there were practically non-existent before, and now there's a whole 10-step process they have to go through, similar to what we have, but there is the ability for them, or not ability, but the step for them where they have to do that. This is what I'm taking and why, and the person has to sign off on and get a copy of what was taken off the device.
Really? Well, that's going to be coming to us soon. I guarantee it.
Yeah, and we're ready for it. We'll get you being able to document this and do screen recording, screenshots, pick and choose. Like I said, we have a lot of these cases where, and maybe you could speak to this as well. I've always known you to be a little more progressive with evidence, with what you need from devices. Mm-hmm. And I remember that was one of the first things that stuck out when we met so long ago, that you were like this. You're like, I don't need everything off of this. I need what I need to get my case done. And, of course, it's on search warrants, exculpatory information and all that. So there's a due diligence there. But you were always like, yeah, just listen, I don't need everything. And I'm a dinosaur. I've been doing this since 1999, with the police department, and, the teachings you got then to the teachings that are now. What do you think about now with an incident that takes place over a 48-hour, a weekend window, with an incident happening, maybe some text messages going back and forth, some pictures, or call logs that show that there were no calls made or picked up, or like they were all unanswered, things like that are typical in a case. What happens when you're doing that, but you get 128 gigs worth of data now? What's your initial thought on that?
I mean, it is, it's a huge issue from the prosecutor's perspective on the amount of data that we're getting in these cases, right? That there's not enough time in the day to go through everything. And if you think about, after George Floyd was murdered, the police accountability bills in a lot of jurisdictions, Connecticut in particular, because that's where I am and I worked, every police officer has a body camera and a dash camera now. So that exponentially increases the amount of evidence, because that becomes evidence in a case when somebody gets arrested. So that increases the evidence that I'm looking at, or I have to look at in this case as a prosecutor. And that just goes, increases when I get, the defendant had 2 phones and there was a computer and we have the victim's phone. So being targeted is not only appreciated, it's necessary, right? There's not enough hours in the day to go through all this data. There isn't. I mean, and that law enforcement prosecutors are making the decisions. Well, we're not going to use digital evidence in this case just because it's not that it's not worth it, but it's not going to get us anything. And it goes back to what you said about that old-fashioned police work. Digital evidence can get us a motive. Digital evidence can get us somebody's thinking, thought process, where they were, what they searched for, those type of things. And that might help, but short of somebody videotaping themselves committing a crime, digital evidence is going to solve a case for us. It's just not. It's the building blocks that we need to prove our cases.
Right.
The problem that we have, it's attribution and authentication. Those are the 2 things that are the biggest issues for digital evidence. How do you attribute it to a particular individual? And you struck me, you were talking about all the different digital evidence and the things that are happening. And defense attorneys are making the argument to judges that because it's digital, it's different. And judge, you should look at this differently because we're talking about digital evidence. And the U.S. Supreme Court cases, Carpenter and Riley, talk about how much information is on a phone, on a device. And to some extent, they are right. It is different because there's so much there. If I've witnessed a crime right now, and you wanted to take a picture, that I took a picture of it, and you wanted that picture off of my phone, and you did a full extraction of my phone, this is my, I don't know, 5th or 6th iPhone that I've upgraded to. I've got pictures of my kids, they're, in their teens now. I've got pictures when they're, 2, 3 years old. I mean, and that's how far it goes back. So that's the issue that we have to think about in law enforcement. So how do we get around that? Well, it's that targeted consent, right? Here's the video, here's the text messages.
Right.
And because we have law enforcement being part of the issue, it'll prevent the argument that we could get from a defense attorney that how do we know how do you establish what it is? You have the witness testifying, you have the ability to testify that, hey, Rich Colangelo sent me this text message saying he's going to kill me. You come in as the examiner. I took a screenshot of the victim's telephone, and this is what, from Rich Colangelo, this is the contact Rich Colangelo. And it might be a 2-step process, all right? We go in and get the contact information for that text message individual also. So it'll give you some context, right? Some of that attribution. What do they have, if it's, Richie C, what information do they have for Richie C under that text message in their contacts? So that's another, just thinking out loud, right? What would allow me to put that stuff into evidence in my case if you just came in with that? Instead of a defense attorney coming in with a screenshot of, hey, here's these text messages that my defendant got from your client, from the victim. Well, the thing that jump out at me, well, or is there a spoofing app? Is there, what was done here? How do we know they are what they say they are? And that's, one of the things that we need to prevent by doing the targeted consent, by corroborating who, the contact is, or, the longitude and latitude in the picture, whatever it may be. I mean, those are things that you're going to have to come in with as the examiner, as the investigator, to help me be able to get it into evidence, right? To get over that authentication hump, and then the attribution hump that I could say that, yeah, it came from the defendant's phone.
Yeah. So building on that, right? You're saying, all right, I've got this text message. I know it's coming from your phone. Hey, working with this person, I brought this message up. It's on anything you bring up on the screen, you can document, right? So you bring it up. These are the text messages. Like you said, it says Richie C. Who's Richie C? But, hey, you mind? I'm gonna click right here on this person's name. It's going to show me the contact information. Take the screenshot. See what I just took from your phone. Does that make sense? Is this who it is? Right. So not only are you documenting what you could pull out in a forensic exam as well, but it'd be shown a lot differently, right? What is the court? What is the jury going to understand? What are your other prosecutors or judges going to understand? But you could build that process. But how about also, as you're doing that, a recording of the whole session?
I mean, and
Your whole
the thing
interaction
that
with the
jumped out at
phone.
me when you, yeah, no, I mean, that would be, and I know the tool can do it. I mean, that's remarkable. And the thing that I was thinking about while you were talking about is, I'm hoping that my law enforcement officer, when they're doing this and having this conversation, and that they're also wearing wearing a body camera, so that I could show what he or she did via the body cam footage also, on top
Yeah,
of video recording of the screenshot. And you hit on something there that we can't forget. We need to be able to present this evidence in a way that jurors are going to understand it. And whenever I was presenting a case to a jury, my touchstone was always, you know, could how can I present it so my mother could understand it, right? Joanne is, 81 now, right? And so, she knows that when you send a text message, you get either green or blue bubbles, depending on, because she texts with my children. So she could understand and see those bubbles. She'll get that. But seeing it, on a PDF of a report with other information there, jurors don't understand that, and that's another reason why that screen grab, the recording of, manipulating through, showing, hey, here's where it is so important.
yeah, I understand that. I understand buttons and swipes and
Correct.
what side of the screen the bubble's on. Pictures,
Absolutely.
pictures tell a great story.
And it's so important, because then, you don't have to spend the time explaining what it is.
Yeah.
And I have an exhibit that could put into evidence, go back into court. They could go back and look at, here it is, in black and white or blue and green or whatever, color the messages are.
Right. Yeah, exactly. Hey, I could tell that's an iMessage because that's my phone, right?
Exactly. And
Yeah.
and that's the thing that we forget sometimes, right? I mean, it is always trying to get the evidence, but getting it and being able to authenticate it and have somebody understand it, there's different steps there.
Yeah. Yeah. Everybody, if you have any questions, please send them through. There is a chat box, or question box. Send them through. Be more than happy to answer anything we can for you. But when using screenshots as evidence, now I know I talk to people all the time about this, was probably guilty of it early in my career as well, um, because I knew the value of, hey, this is just too much. We're not going to get this case done for 6 months if I take everything. So we got to be targeted, right? Triage,
Mhm.
mobile targeting. So victims of thumbing through the phone ourselves and using a camera or using your own phone to screenshot, um, and kind of put that in. I mean, I would think, and I know it's been taught, that doing it that way can run into chain of custody issues, and also tying up your own device if you
And
use
that,
your own
that's
personal
that's
device.
a huge thing. I mean, if you utilize your own device, um, we're gonna, run the risk of a defense attorney asking for an examination of your device. And that's something that I always cringed at as a prosecutor. How am I going to prevent this from happening? So, do
Right.
you have a protocol where if you take a picture of something using your own device, you email it to yourself so you could document it? You have someone hash that picture as soon as it gets into, and you put it into evidence, and then you delete it off the device. Maybe, and you think of it as similar as your notes, right? When you take notes, if you once you incorporate them into your police report, you're going to get rid of your notes. well, that's something to think about. But utilizing a tool, I mean, the great part of the ADF tool, honestly, is that it's portable, right? I could put it on my laptop. Yes, in order to do the screen recordings, I'm going to need to be on the same Wi-Fi network, right? So maybe I have a hotspot that I utilize to be able to do that. Or if so you could use the screenshot function in the field without being connected to anything. And that's what makes it so valuable. Um, while you're out there doing your search warrant, while you're out there doing your investigation initially of a crime, you could be capturing this data. And,
Yeah.
we do kind of look at law enforcement does a lot of things right, but one of the things I think we do wrong is we do our investigations backwards. Right? You're going to get a suspect. You're going to want to talk to that suspect as soon as you can. You're going to arrest that person as soon as you get probable cause and we have a warrant for their arrest. And then all the forensic stuff's going to get done later. I mean, if we have the ability to have the forensic examination done before we sit down and talk with the suspect, so we have that information available to us for that conversation, we're going to settle a lot more cases. We just are.
Yeah.
And it changes the dynamic of what how the investigation goes. But being able to be targeted and capture certain things, even if we have a search warrant, maybe we do it, use a combination of tools and do it that way. But getting the information quicker to be able to have it for those conversations is just invaluable.
Right. Yeah. Especially victim witness, or they're talking with somebody who maybe isn't known at this time. So grabbing this information quickly, starting, maybe preservation orders, right then and there, starting finding out who they are through their profiles, their information that you need that you might not get. Um, Whether a physical has to be done on it or not, and whether the information is going to come off that right way. Do I
That's a
have these tools available to me, or am I going to have to send this out somewhere? All questions.
I mean, and it's a huge point. I mean, we were talking about just text messages. What if it's a DM through a social media application that, it's somebody's screen name, and now we don't know who they are. So you're right. We have to run preservation letters, and when we're doing those requests, we have to make sure that we're not only asking for, account information, but we want to make sure we're asking for recovery emails and recovery phone numbers, right? Because people, while I might set up an account for, you know, RJ the Great, I'm going to use my cell phone because I want to make sure RJ the Great, I could always get on it, right? And those are the things that, we're finding more and more with individuals. And that's kind of like the gift that keeps on giving to law enforcement from these companies with their two-factor authentication and, um, recovery email, recovery phone numbers. So that's
Yeah.
huge. And you
Yeah.
touched on it a little bit, right? That investigation is where are we looking? How are we getting that information? We're going more and more to open source information and gathering that, and we're finding that victims and witnesses are doing that too, right? They're Googling everything they possibly can if they see something happen. If they have, look, who's that car? Who's that? Who's this person? What? How could I find them? Um, Right, and it's happening. So, we might have those screen crap captures to grab for their searches, for their, the websites they went to kind of figure out who the bad guy was. And
Yeah.
that's really helpful.
Yeah. You just, yeah, we were talking text messages, basic, bring it up, but you got to remember, if you could bring it up on the screen, you can get a good screen capture of it. So think of things that may be in the cloud, that even if you do a physical and you don't have cloud access, that may not be on the device, or maybe not getting into a photo vault. When you have it there and you have the cooperation, maybe you can get into that vault and get that information. One of the other things is what do you think of the undercover cases we mentioned earlier. So you have somebody doing their chats, and that's gone from computer to mobile now. So a UC officer in these types of cases is having a specific conversation with somebody. So instead of dumping that whole phone and everything that's on there, even though it's probably an undercover phone, there's a lot of information on there, but just at the end of the day, capturing, what I did with this person and putting it in the case file, right?
Well, I mean, if you think about what we did, in the, our internet relay chats, right, when we first started, right, and doing those screen grabs for those conversations, that's exactly right. Getting a whole, a video of the whole conversation, instead of screenshots, scrolling through the whole thing to be able to see the flow, is huge. And from a prosecutor's perspective, that's all I need for the case. I don't need everything else from the phone. I don't need an extraction every time you do a conversation. I need the conversation.
Yeah.
And I need it quickly to be able to make a determination on whether, to fend off the client was, from the defense attorney, my client was, entrapped. My client wasn't inclined to do or say any of this stuff. They were coerced into doing it. Pulling up those conversations right away, being able to provide those video snippets of each conversation is hugely helpful. And it protects, look, we're like in those type of cases, right? We're protecting kids, right? Realistically, you know what I mean? And it prevents, trials. We're able to, do what we need to do quickly and efficiently.
Yep. Yeah, I think, I talk to a lot of people. A lot of people go to court a lot. But I'll tell you, here, I think we always had good relationships with our courts. You were in a different court system, but working with you and having that, working with our courts, I can tell you, out of the years I did it, I didn't really need to testify that much, or there were court step deals made before they actually walked into that courtroom, because it was just
And that's the
overwhelming
benefit
and
of the
doing
digital
it
evidence.
right and getting it.
Yeah, absolutely. I mean, that's the benefit of, getting, the strategic targeted evidence, being able to tell that story, provide the information quickly, it saves the victims from having to come in and be re-victimized. And that's ultimately what we're doing if we're getting a whole extraction of a victim's phone and providing it to the defense attorney. We're re-victimizing them when they go and get cross-examined in that situation because we weren't protective of them like we should have been.
Yeah. Do have a question here. So regarding screenshots of an iOS device, if you're unable, okay, so this is a technical question on the tool itself. If you're unable to obtain the Apple ID and password to use the screenshot tool with MDI, are there any legal issues with me taking screenshots with the analyzed device and then pulling them through the photo extraction of the digital examination? Well, there's one here, one question, unable to obtain the Apple ID and password. So with iOS, this is an issue too. Being able to use a tool, Apple decided to put a developer mode on in iOS 16, which if you want to take screenshots from their device, it needs to be a developer mode. And to do that, you have to turn off the passwords and get the Apple ID. So some victims are willing to do that, others are not. But there is a workaround with that, with the mirroring. If you can get it to mirror, it doesn't need developer mode, and you can take screenshots of the device being mirrored. So that'll solve that. The second part, are there any legal issues with me taking screenshots with the analyzed device and then pulling them through the photo extraction? I see what you're saying. So this is a good question. I don't know if you've ever come across this, Rich, where he's got the device in front of him
Mm-hmm.
and he didn't, he needs to get something off of that. Maybe the tool they're having isn't working, so he uses that device to take the screenshot and then pull it off in an extraction.
Look, I mean, if that was used or utilized in one of my cases, would I argue that it should be admitted into evidence? I would. Right now, we have the ability to look, and it's going to take the examiner to have to, it's documentation so that you remember it, because right, when it comes to trial, it's going to be, a year after you did it.
Right.
So we need to remember what you did. But
Yeah.
being able to say that, hey, I wasn't able to get this information from the tools that I had access to. The only way I could do it is this. Um, one of the great ways to be able to kind of bolster that testimony, throw a body camera on so that you could show what you're doing, or have a video camera running over your shoulder while you're doing it so you could show
Right.
what you're doing. That's the best documentation. So that, there's no question that you didn't make any changes. All you did was take a screenshot and then you did the extraction.
Right.
If you're showing that you document it, and here's the problem with law enforcement, right? And I don't know when it happened, but it happened in our careers, Rich, when we were working before we retired, is that, if it's not in a police report somewhere, it didn't happen, right? That jurors believe that because defense attorneys are arguing it and judges are starting to think that. So by making sure you document it, you kind of cover that aspect of the,
Yeah.
the questioning that people might have.
Yeah. I get the question, and completely understandable, and great answer. I could hear a lot of forensic examiners cringing, rightfully so, sometimes with using the suspected device. So I would do anything I could in order not to do that. But like you said, if it is done, documentation, and again, you were always like, okay, you gave it to me, I'm going to fight to get this in, right? We've got something to get done here. So yeah. Awesome. And like I said, there is a workaround on that now. So if you can mirror it, you can get that information. And comments, you're talking about documentation. Uh, I always, you teach a tool, you talk about its uses, and I'm always like, there's a comment section, use it. If you're taking a picture or a screenshot of something, put in there why you did it. Because a year from now, a year and a half from now, you've already done 100 more cases, and you're like, where was my thought process when I took that picture? I can't
Absolutely
tell
right.
you how many times I would be working on a case for a couple hours, and then somebody taps you on the shoulder and says, "Hey, you got to go. You got an emergency." You come back and sit down in front of your case, and you're like, "Where was I? Why am I on this screen?" Right? Because you lose your train of thought. So type it in. I took this picture because on the wall there's a certificate that shows they went to this school or they're in this area. Right? So. Comment,
And that's
comment, 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 comment.
the huge part, right? Is that the investigator is going to know more about the case than the examiner, and then the prosecutor is going to know more about it than anyone once they get into it. So not knowing that there's a documentation of a school in the background of a picture, because you saw it, you glanced over it because you didn't think it was important, but now it becomes important to me. So how do
Yeah,
I, where do I get that from? And that might be my
yeah,
frantic call. Hey, were there any pictures that showed this? And that's what we
right.
need.
Yeah, yeah. I always remember those calls.
Yes,
um, so we're coming up. We talked quite a bit. I think we got a lot out of this. So um, my last question, and I know we talked about this earlier, and I don't think there's really anything out there, but when using screenshots or screen recordings as evidence, have you run into any case law or legal issues as far as it gets to court and say, no, you should have had the whole thing?
I haven't, and I did kind of look around to see if there anything popped up that I might have missed, and I didn't find anything. But right, it goes back to authentication and attribution, right? So being able to authenticate it for what it is, and because you have a cooperating witness, victim, being able to testify that, hey, I gave consent to the officer, the examiner, to do this. The examiner come in, I use this tool, this is what I did. we could authenticate it, right? And now the attribution is, how do I tie it to, RJ the Great or
Right.
whoever the defendant is, right? And
Right.
it gives you that additional step of, maybe it's an open source, what are the screen names he uses, or maybe it's just a contact for Rich Colangelo has RJ the Great in it,
Yeah.
whatever it may be.
Or the good old fashioned police work. You sit down, you write a subpoena or an ex
Right.
parte order for the information. Right. There's always ways to back it up. Good old fashioned police work.
Absolutely
Doesn't
right.
take. I used to write those things in my sleep. I think it took 5 minutes to get it done and fax it off. So always good ways to. I'm sure you would love to see that come in. Hey, not only do I have it here, but I backed it up with the legal record.
Absolutely right.
Well, that's what we have. We answered some of the questions that came through during our talk. I really, really do appreciate you taking the time and spending it with me here today. I think it was great. I think the information is invaluable for people, and it shows you can do it, you can use it, it's acceptable, and not to be afraid of it. It's good old-fashioned police work first. Most of the time, you're going to prove your case anyways. Right?
Thanks for having me, Rich. I had a lot of fun. Have a great day.
All right, awesome. Thank you. All right, thanks everybody. There will be a recording sent out on this, and you can find it on the ADF Solutions website. Thank you all for spending your time here today.